So, what is becoming a regular occurrence in our society is the abuse endured by a wife after the death of their husband, and particularly in the hands of the husband's family. So, now what do you do when you find yourself in this position as a wife, where, for example, they are depriving you of access into your marital home, threatening to evict you, planning your husband's funeral without you, or even unjustifiably enriching themselves with your husband's assets? Anathi, does our legal process or system afford wives who find themselves in this position any sort of protection?
It is rather unfortunate, Zintle, that a lot of women in South Africa do find themselves in such a horrific experience whereby you have just suffered a loss of a lover, your best friend, your supporter, and your protector. And the people that are supposed to be your support system are the people that are actually causing hell and making the experience even more unbearable. Just to add to the examples that you've listed, there are extreme things that a family can do to a woman who has suffered a loss of her husband. For instance, you did mention some of the things, but sometimes the widow will be evicted from her home or prevented from entering the homestead, or the family will take original documents, original IDs, death certificates to prevent the spouse, the surviving spouse, from claiming or possibly claiming any benefit or any money, whether it's rightfully due to her or otherwise. However, luckily for women in South Africa, we do have a progressive legal system. We do have progressive judges that not only apply the law formalistically, but they apply it in a way that does not just for punishment, but also for protection. For instance, there are options available for women who do find themselves in such an abusive situation, because indeed one can classify it as what is recently called Makoti abuse. So if you do find yourself in this situation, the court systems are there to help and assist anyone that does need help and assistance.
Okay, now that I understand, now let's make an example. Hypothetically speaking, there is a lady by the name of Lisedi. Lisedi finds herself in this position after the death of her husband. Naturally, she'd want to take the forefront in planning the funeral, in maintaining her marital home, but she's not prevented from doing so at the abuse of her now deceased husband's family. What sort of measures does the law afford us to help protect Lisedi from enduring such abuse?
Like I said, South African women are very fortunate to be in a country that does protect women's rights, that does protect children's rights. And one of the ways in which these rights can be protected is a form of a legal remedy called an interdict. But before we even get into the intricate details of an interdict, it's important to note that an interdict is not a court procedure, but rather it is a relief that is sought from the court utilizing application procedure. Now, to get into what is an interdict, there's two types of interdict, or two main types of interdicts in the South African legal system. The first being the prohibitory interdict. What this means basically is when you go to court and you ask the court to get someone to stop doing something, either to stop them from infringing on your rights or to prevent them from future harm that they might cause. Then we have the second type of interdict, which is a mandatory interdict. What this is basically the court either forcing the party who's infringing your rights to do something about it, or to force them to, or compel them to do something. So those are the two main types of interdicts that we do have in our legal system.
So, Anati, how would those two types of interdicts apply in Lisedi's situation?
Okay, so let's first deal with the first type, which is the prohibitory interdict. So, for instance, let's say Lisedi is hearing rumors or is experiencing some sort of, or she can foresee that the family is either going to prevent her from collecting her deceased husband's body from the funeral parlor, or she's hearing that people are threatening to take assets, whether it's the car, whether it's cell phones, whatever the case may be. Then she can seek legal advice to get a prohibitory interdict to prohibit either the family from prohibiting her from planning or arranging the funeral, or to prohibit them from taking assets, because we do know that that is one of the main issues that widows in South Africa face, that while you're still grieving, there's people that are literally in your house to shop. They actually take assets that rightfully belong to you and your children. So if you do find yourself in a position where you know that if your husband were to unfortunately pass away or unfortunately die, there's certain people who are going to come and want to claim what is rightfully yours and what rightfully belongs to your children. So then she can get a prohibitory interdict, which will prohibit that from happening if it hasn't already happened. Now, let's go back to the second type, which is the mandatory interdict. Now, let's say Ulisedi is late to prevent them from taking the assets. And let's say Umagazi has already taken the assets, or Dabao have already come, they've taken things. Now, she can't prevent them from taking them because they've already taken the assets. Now, what she can do is to get to court and get a mandatory interdict. Then what the court will then do is they will force or compel whoever has possession of these assets to return the assets back to Ulisedi, and then they'll be distributed if the deceased had a will, in terms of the will, or in terms of the Interstate Succession Act, which is according to the laws of our country. So that is how the two types of interdicts can be applied in Lisedi's situation. Let's say now Ulisedi does find herself in this situation, whether it be she needs to prevent someone or the family from interfering, or she needs the court to force people to return assets back to her. Then what she can then do is, it is called applying to court for an interdict. Now, to apply to court for an interdict, it is usually through the application process. What this means is that she will then have to give the court evidence in writing in the form of an affidavit stating the story, the situation, and it must be supported by evidence. So it has to be either documentary evidence. However, if the court does feel the need for oral evidence, whereby people will then be called to testify, then that will be then in extreme cases. But usually it's dealt with on paper. Then she will then be what is called an applicant, who will then apply to court for an interdict. However, there are certain requirements that Ulisedi, when she does decide or when she is applying to court for an interdict. Now, there are four requirements rather, that she would need to satisfy the court if she does want to get either the prohibitory interdict or a mandatory interdict. The requirements are the same. So the first requirement that she will have to then meet or satisfy the court with rather would be a right. So she will then have to give the court that I am the surviving spouse, I have a right to these assets due or by virtue of my marriage to the deceased in community of property. That's simple. It has to be an established right. Then she has to then support her claim that she has a right to either the assets or to be able to prevent the other people from interfering. The second requirement that she will have to satisfy the court with is that there is either actual harm or the threat of harm. So harm doesn't necessarily mean physical, like harm or physical abuse, but it technically means that you stand to suffer a loss if this remedy, which is an interdict, is not granted. Be it financial, be it the fact that you can't bury your spouse, but whatever harm, you'd have to then, like I said, support with evidence. Yes. The third requirement that the court will look at is what is referred to as a balance of convenience. So what this means is the court will then look at, okay, cool. So Ulisedi, if we are saying that Otabao must be prevented from taking these assets, which of these situations is the worst? So Otabao never had these assets and she was fine without the assets. Ulisedi has a right to these assets. Now, if she loses these assets, she stands to suffer a loss. So now the court is forced to weigh which is more detrimental. You living without what you never had, or the other side losing what they were already utilizing. Lastly, the court will then consider whether you have an alternative remedy. Could you, as a family, have sat down and spoken about it? Could you have applied maybe to another court or whatever other alternative remedy? Because one thing about our court systems, they are heavily backlogged. So if you can find a better way to settle or to resolve issues, the courts do encourage that. However, if you don't have another way, then you're forced to come to court. For instance, you can say we had a family meeting, it didn't work out. They didn't hear me. Instead, I was ushered out or carried out of the meeting or dismissed. So, High Court, I have no other way. You are my only protector in this instance. So if she is able to meet those requirements or actually satisfy the court of those 4 requirements, then the court will then take into account a few things other than those requirements. The court will also take into account the interests of justice, which is why I said earlier that South African women are very fortunate that our justice system is one which is progressive. Yes. So if it is in the interest of justice, it might not be in terms of balance of convenience, but if it is in the interest of justice, so the judiciary does have what is called discretion. Even if you might not meet them to the T, however, if it is in the interest of justice that we grant this order, then the court will then make that decision.
So Anathi, we know how busy our court systems are with the backlog. Now let's say Lesedi is in this situation and she needs urgent assistance. Are there additional requirements that need to be met in order for Lesedi to bring this application on an urgent basis?
Okay. So being a legal practitioner, so my first advice would always be seek legal advice, because interdicts are it's an intricate system. It's an intricate process rather. So seeking legal advice will be of assistance, because then they'll be able to bring to court what is called an urgent application. Depending on the urgency, the application might even be heard at night. It might be heard during the weekends, depending on the type of urgency. So for instance, if Ulusedi finds herself in a position whereby the family is preventing her from burying her husband, now that is something that is urgent, right? She can then apply to court and say that the planned funeral is on the 20th of April. Today is the 17th of April. They are prohibiting me or preventing me unlawfully from collecting the body from the funeral parlor, because the funeral parlor is saying you need to collect the body today because you guys are arranging the funeral for a specific day. Now, she doesn't have the time to wait for a normal court process, because the normal application, you'll serve your notice of motion, give the other side 5 days, then they've got 15 days to reply. She doesn't have the luxury of time. Now, what your legal practitioner is going to do then, they're going to draft an application and launch it on an urgent basis. Now, in terms of urgency, now you've got your 4 requirements. Now, to recap, it was a right, irreparable harm, balance of convenience, and no other alternative relief. Now, if it is urgent, now you've got an additional requirement that you'd need to satisfy the court, that this matter is urgent. The court, unfortunately, you'd have to put your other matters to the side, which is now you'd have to then be able to convince the court that not that the other matters don't matter, but this, if it is not heard today, tomorrow it won't be as effective. Yes. So an urgent application is something that is possible even the day before. It is something that is possible. So if you are in a situation where you do need urgent relief, the courts are available. There should always be a duty judge in the jurisdiction of a high court.
So, Anathi, I also remember reading a recent judgment. It was actually a judgment passed in 2023, whereby now this wife was married in customary, or according to the customs of South Africa.
Okay.
Now, when there's a dispute relating to the registration or the validity of the marriage, what would normally occur in those circumstances?
Okay, so if you are married in terms of the Civil Marriages Act, or the normal way that people are usually married, where you have a marriage certificate, then it's easy, you just attach your marriage certificate. However, if you are married in terms of a certain tradition, in terms of customary law, and then marriage is not registered, even if you are married in terms of customary law, you are and you can register your marriage in terms of customary law. However, let's say Ulisedi and her unfortunately deceased husband, they did not register the union or their marriage. Now, she's in a situation whereby either the family does not want to recognize her as a spouse, then she's in a difficult position. If the family recognize her as a spouse, then it's fine. Now, if there's a possibility that they might not recognize her as a spouse, then in your interdict papers, it is vital for Ulisedi as the applicant to show the court that, one, certain steps that were taken, for instance, customary law, it is also legislated. So there's certain steps that need to be taken for it to be considered a valid customary marriage. So for instance, if ilobola has taken place, whether ilobola was paid in full or not in full, ilobola has taken place. Was it celebrated, for instance, in the Xhosa culture, ukiso utsiki, then if those things were done, then one can consider it to be a valid customary union. Now, to refer back to your statement about the judgment, that judgment is a great judgment by Judge Norman. She is one of the people that I consider to be a progressive judge, in that, yes, you might not have met the requirements to the T in terms of a customary law whereby the lobola was not paid in full. That does not invalidate the fact that the lobola aspect was present. However, if you don't have that, you're allowed to have what is called confirmatory affidavits, which would be affidavits from people that know or were there at the time that the customary union or the customary process was undertaken. Then you attach those people's affidavits to the court to say, in terms of a balance of probabilities, because in terms of civil law, that is the standard. In terms of a balance of probabilities, if ilobola was paid, these people are confirming. Surely one can adduce that it's likely that this person is telling the truth, that they were indeed married to this person. So she doesn't have to prove beyond a reasonable doubt, or she doesn't have to prove the standard for civil is not as intense. She just has to prove that on a balance of probabilities, as a reasonable person, if ilobola was paid, I was living with this person for this amount of time, these people were present, what are the chances that we weren't married? Yes. So just because there might be doubts, it doesn't mean that Ulisedi should count herself out. The courts are there to take into account reality. The courts are there to take into account that we do come from different cultures. So the courts are in a position to develop the law, which is why the judgment you're referring to is a milestone. It's a very important judgment, because that is exactly what was happening to the applicant in that judgment. However, Judge Norman, besides the fact that it was being questioned and it was in fact doubted that they were married, ordered that she may not be evicted from the homestead. And instead, the family members that are occupying the property, they need to leave within 30 days. So reading into that, it means that this marriage between the applicant and the deceased is a valid customary union. And as a result, she is entitled to 50% of the assets. And that includes occupation of the homestead and the home.
Thank you so much, Anathi, for joining us today. If you ever find yourself in a position whereby you consider yourself as another Lesedi in our society, please do make sure that you contact any trusted legal firm to be at your assistance.